what is a successful prosecution in a domestic violence case? That's our topic for today. Now, honestly speaking, it could be a generic topic. What is a successful prosecution? The first thing you have to understand is, what are you asking for? So, what are the reliefs that you're asking for? I have seen a lot of domestic violence petitions, some of which have also been dismissed eventually, where the person asks for everything. मतलब financial maintenance, स्त्रीधन, residence, सब कुछ मांग लिया. The point is, and you allege everything under the sun. So you allege sexual, emotional, physical, financial, all kinds of violence. Now, it sounds very dramatic when you put it down on paper. And initially, it might even get you results. So there are two ways of thinking. The first way, which I will say for myself is not my way, I do not practice like that, is that you make the wildest allegations in the world and somehow the judge is roused to so much sympathy that आपको preliminary कुछ interim maintenance मिल जाती है. And then you push forth your advantage, you keep on extracting this maintenance, you make the respondent tired and fed up, bring them to a negotiating table and you negotiate. Okay? Now the difficulty is that what I'm noticing in the last few years is that the husbands are now fighting back. So it's not so simple anymore. And sometimes itna usko hype karne ke chakkar mein, you make out a case which is not sustainable. In fact, very often that is what happens. This is exactly what is happening in some of our matters which are currently pending. The opposite counsels are, even though we haven't got interim maintenance yet fixed in the matter because of COVID, the opposite counsels are approaching us time and again ki settlement kar lo, settlement kar lo, settlement kar lo. Why? Because the case that we have put up is a case we can prove. And we have only alleged what we can prove. We don't allege what we don't or we can't prove. Right? So I subscribe to the second kind of approach to domestic violence or any other suit for that matter. Allege what you can prove. By and large, you allege what you can prove. Or if you're going to allege something that you can't prove, let it be something which will be not so material. If you have alleged 12 cases of domestic violence or abuse and you are managing to, find proofs for 10, it's okay to have 2 that you can't prove, because you can tell the court that everything I can't prove because only the 2 of us were involved or whatever it is, right? So, but if you have alleged 12 instances of domestic violence and you can't even prove a single one, or you have alleged something quite horrendous and clearly you are unable to prove it, then it becomes a problem. Okay? So one of the matters that we got into a little later in the day, what had happened was that an allegation of 377 had been made against the husband. Now, the fact of the matter was that this allegation was actually the truth. And it had actually quite shocked the wife so much, and she felt so vandalized and brutalized that she actually suffered from a psychiatric issue. But the difficulty was twofold. One, she never went for a medical examination when it happened. And secondly, even though she had to, go to a psychiatrist to get her mental health situation rectified, she never made any complaints about it except when she filed the domestic violence. She went to a lawyer, she told him what happened, he just translated it without thinking. Now, I had a conversation with her psychiatrist, and her psychiatrist was very clear. He said, if she has to relive this in a hostile environment in the court, she will probably collapse and fall to pieces. So I sat her down and then I explained to her, I said, look, you may completely go to pieces. You may not be able to prove your allegation also. So you're going to start feeling that it was such an exercise in futility and it was worthless and you suffered so much. And you're going to want to walk away from the entire case. But the fact of the matter is that maintenance is your right. There has been financial violence apart from the sexual violence. And maintenance as your right is something we can prove. Residence as your right is something we can prove. So let us concentrate on those aspects. Right? So we actually filed an application informing the court. We got an opinion from the psychiatrist, put it into court in a sealed envelope for the judge only to say that he felt she was too fragile to testify on this account. And so we said, on this account, we are dropping this particular charge. We are not going to pursue it further. And then we proceeded with the rest of the domestic violence. So please remember that every charge you make, it is your job to prove it beyond reasonable doubt. And don't be led astray by people who tell you that, oh, the presumption is in your favor and actually he has to prove he didn't do it. The courts are not there yet. The courts will look at proof. They will look at the overall picture and they will look at the fact that you told a lie if something is proven to be a lie. And so therefore, please be very careful whenever you advise your clients to go a little extra mile, then you must do it keeping in mind the Evidence Act with the clarity that you have the proof which is required if push comes to shove, if you are forced to fight this case till the end. Because remember one thing, if the domestic violence is dismissed, 99.9%, even if there is financial violence, that charge will also be dismissed. Maintenance nahi milegi. So you'll have to fight very hard. You have to go back to the court. You'll have to tell them that despite the fact that she ostensibly lied, she is in dire straits. This act is for the purpose of keeping people from destitution, blah, 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 blah. You might have to go in a 125. So it becomes problematic. So don't create those problems for yourself. And please, we have not one, but multiple cases where, people will create false evidence. All I can say to you is that please remember one thing. या तो चोरी करो मत, और अगर करो तो फिर ऐसे करो कि पकड़े मत. But ऐसी चोरी करो कि आप पकड़े जाओ, that is the worst thing possible for your client. And repetitively, this has happened in our presence. So in one case where we were for the respondent, the victim alleged that she had gone to her husband's native place, and there she had stayed for a week, and she was ill-treated by not only her husband, but also by his father, his mother, one widowed sister who was living with the parents, and also by the widowed sister's 2 children, right? And now, fortunately, she alleged that this is what led to the whole domestic violence happening against her. This is what led her to take the matter to court. So within about a month or so of this particular uh, incident, as she narrated it, she came to court. And luckily for everyone concerned, the husband came to us. So we immediately asked for the cell phone records because we said that she was in uh, some other state, some other city at the time when this particular incident is supposed to have taken place in the native village. Now, at that time, suddenly everybody started scrambling because her phone was not uh, uh, in the area where she claimed it was. So immediately in response, the lady claimed that actually I forgot my phone and I didn't have my phone with me. And then we pointed to her pleadings to show that she had claimed that she had made a lot of phone calls and informed a lot of people about what was happening. And she tried to take help from her own family and her husband's family. And eventually, on the basis of a phone call, her father had come and he had taken her away from there, and she was in a very shattered condition. So clearly, we told her that you must have had your phone with you because you don't say that you use someone else's phone, you use your own phone. And now you're saying you don't have your phone when we are asking for the cell phone records, you're saying you left it behind. So we still want to see whether or not calls were made from that phone, and if they were made, who made those calls? So the nutshell was that after this whole thing happened and after we insisted that if the judge did not grant us this cell phone records, then we would move a 340 against her and she would pull it out, have to pull it out. And there was a lot of drama. Eventually, the wife came on the table and she settled. And our client had told us that he was willing to pay a certain amount of money to finish it off and file a mutual consent. Because of this whole thing that happened, when the negotiation happened, um, the amount that was settled was 50% of what he had originally told me he was willing to pay. So this girl lost out hugely. Now, what I'm saying is that we were for the husband. So it was our job to advise our client and to protect our client. But having said that, what I'm saying is that this may be a situation where the poor girl got the raw end of the stick because her lawyer made a mistake. And very often the clients tell us that ये मेरे lawyer ने बोला डालने के लिए. He said अगर ये डालोगे, she said अगर ये डालोगे तो तुम्हारा बहुत अच्छा केस बन जाएगा. Please don't give such advice to your clients. It is very wrong. Like I said, झूठ बोलना है तो ऐसा बोलो कि उसको कोई तोड़ ना सके. So always when you make a statement, look at what exactly you are saying and what will be needed to prove that statement. Also remember that अगर आपने 4 statements करी और 3 आप prove करने के काबिल हो गए, then the presumption could possibly work for you in terms of the 4th month. But अगर आपने कुछ भी prove नहीं किया या उसमें से आपने बोला कि जी these statements I can't prove because there is no proof, and the respondent is able to disprove one of your statements, your whole case will go. So this is the first thing to remember. For a successful prosecution, please do not make wild allegations in the air. Keep it real and keep it to what you can prove. कि खुदा ना खास्ता अगर कोई जम के लड़ने को बैठ गया, at least you are able to fight till the end, right? So that is the first thing I have to tell you. It is bad practice to get short-term gains for a long-term loss. Okay, that's the first thing. The second thing I have to tell you is that please remember what is domestic violence. I don't know if any of you are planning to join the course. We're going to do this in great detail because what we're going to do is I have decided it's a small act and we can afford to go through it section by section, because when we are doing that, we not only learn about the Domestic Violence Act, but we also learn how to read the law. And that I find is a problem these days, that a lot of people who come out of law college know a lot about legal research, but they don't know how to unpackage a simple section, because nobody took the time to ever tell them that. And it will take them 5, 10 years, 15 years to just learn that every section needs to be unpackaged and understood in its entirety. Okay? So now, what constitutes domestic violence? Domestic violence is any form of abuse. Okay? It could be financial, it could be sexual, it could be physical, it could be verbal, it could be threats. All of this is clearly within the ambit of abuse. Right? However, domestic violence is only to be viewed in a situation where either there is a matrimonial home or a shared household. So for the first time in the Domestic Violence Act, because you have recognized that people can have live-in partners, the Domestic Violence Act extends to live-in relationships also. But please remember, a lot of times what happens is that people will file domestic violence cases against the father, the mother, the brother, the sister, the great-grandfather. You can't do it unless they are living with you. It has been interpreted time and again. It is very clear. You cannot file a domestic violence against a person who does not share a household with you. Okay? So that is the next important thing to remember, that you have to show in your pleadings how the domestic violence was carried out by the persons who were present in the shared household with you. Okay? And shared household also, before you start claiming that a particular household is a shared household, please check. There have been various interpretations of what is a shared household, right? So you must fall within the ambit of those interpretations. Otherwise, you don't clear the base for a shared household. Okay? So in one of our matters, and this was way back, and the Domestic Violence Act had just about come in. Okay? And people were still grasping the intent of the act, the whole ambit of the act, and so on and so forth. So what had happened was that there was a very high-ranking government official. He was married. He had children from that marriage, but he um, had started an affair with a woman, and as a result of that, she had a child. Okay. Now, she alleged that he had gone through a form of marriage with her, but she had no proof of this. Okay. However, she was willing to undergo a paternity test for the child to prove that it was his child. Now, she was staying in a particular locality. So I think we were one of the first people to file under the Domestic Violence Act. And what we alleged was that this man had come and he had stayed in that particular premises with her for some days at a time and then gone away, claiming that he had to go back, and that if he had filed for a divorce from his wife and if it was discovered that he was having an affair, then his divorce would not be granted to him. And so, therefore, we believed him, and he said he would marry us once the divorce was final. We believed him, and so we were willing to let him come and stay for 5 days, 10 days at a time. But all the while he was there, he stayed as a partner or a husband would. Now, of course, this gentleman refuted everything, and the matter boiled down to, can we or can we not prove that this was a shared household? Because if it's not a shared household, there is no domestic violence, and then financial maintenance, this, that, and the other, everything goes. For that purpose, we produced one friend, one neighbor, and one cleaning woman, all three of whom testified that they had seen this man. They had found him. The cleaning woman testified that when she used to come even at 7 in the morning or 6:30 in the morning or whatever it was, he would be there in the house, clearly having spent the night. The neighbor testified that he used to come and stay for 5, 7, 10 days at a time sometimes, and that they always assumed that he was her husband. They didn't like to ask too many questions. And they assumed it was a bigamous marriage. This is what they testified. And the friend testified that there were many occasions when she used to come and spend, maybe stay overnight with her friend, and few occasions she was, told that, okay, from this time to this time, because he's going to be coming, so I can't have you staying overnight, and, etc., etc. So their programs had to be shifted around. This was the testimony we gave, and it was believed. And as a result, the domestic relationship having been established, it was established that this woman was, who had lost her extremely well paying. She was a very highly qualified woman, very, very intelligent, very highly qualified. She was holding down some UN consultancies, all of which she lost because of this whole debacle, because she had a child and so on, didn't know where to leave the child. So, 50% of his salary was given for her and the child's maintenance so that the child could be sent to school properly, etc., etc. And that was a huge amount at that time, actually. And it was as a result of that that this gentleman then came forward and he said, let us talk settlement. I cannot give you 50% because it would be impossible for me of my salary. So anyway, the matter was resolved. So what I'm telling you is that we had it very clear in our heads. We had obtained affidavits from all these three people, and we had already got them in our possession, testified by the oath commissioner prior to or at the time of filing the deed. So that if for any reason they decided to change their stance because they were approached by the husband, we had something to prove. Okay. So, like I said, a successful prosecution depends on what you allege and how much thought you have put into what possibly can be the, what shall I say? What can possibly be the ways in which you can prove it? Okay. All right. Now, are there any questions?
Yes, ma'am, we do have questions. Actually, a Madagascar of questions in variety and as well as in quantity. I'll just take a second.
Yeah.
Okay. First of all, I'll just leave the link in the chat so that you guys can look at the details of the course in the meanwhile. And not only this one, do try go to the e-learning section. There is another course that ma'am has already done on CPC. It's been an excellent course. We've learned, like, knowledge would be a very small word. We've taken life lessons in that course. So do check out CPC, and there is Hindu law, CRPC, and many courses. Do check them out. The link is in the chat. Okay, starting off with the questions now, ma'am.
Yeah.
First one is that this is a little long. How to tackle a case when the whole family is prosecuted? You've already talked a little upon it, but there is an addition to it. How to tackle when the whole family is prosecuted and the police is actively involved in trying to bend you down to an unconscionable compromise? And also, what is the remedy to, kind of get compensated after you have suffered a loss because of wrongful confinement or arrest?
The remedy is malicious prosecution. You can file against a person for malicious prosecution. That is one. You can file against a person on charges of 340. That's another. You can file against a person under Section 44 of the Evidence Act that they've obtained a decree by falsifying evidence or giving incorrect information to the court. Okay. So there are a lot of remedies, right? You know that 340 carries a 7-year imprisonment, and it's very unfortunate that most people don't really follow through with the 340, because once the case comes to an end, they just say, okay, we've had enough, let's go home, whatever it is now. And a lot of domestic violence cases, in fact, I know that there are certain lawyers who specialize in just getting settlements done any which way, right? So whether they persuade their client or whether they persuade the opposite party that they are getting a good deal, somehow they get a settlement. I mean, there are some lawyers where 90% of the cases will end in settlement. Okay?
Right, ma'am.
They get very agitated when you actually say, no, I'm not going to enter into any settlement. I want to prosecute this case, whether they are for the respondent or for the victim. Okay?
Right, ma'am.
So that is one, right? Now, the second is that the whole family being involved. There's something that's moving on the screen. I don't know what it is.
Ma'am, sorry, it was my hand because I was receiving a call.
Yeah. Okay. Yeah. Okay. So the second thing is if the whole family has been involved. If you happen to live in a joint family, then yes, the whole family can be involved, and then there is nothing for it but to fight the case through. Unless there is a compromise or something, or if the person has not given any specific allegations against you. Please remember, for a successful prosecution, you don't have to make vague allegations. If you make vague allegations, it's no good. You have to specify that on so and so date X happened, or on so and so date Y happened, or on around this time this happened. So, supposing a person says that on 20th of October, my father-in-law hit me and kicked me, and my mother-in-law held me down while he hit me and kicked me, and my sister-in-law was verbally abusive at the time, and she pushed me down before my father-in-law hit and kicked me, and my mother-in-law held me down. Let's say these are the allegations, right? Now, if you can prove that the father-in-law and the mother-in-law were actually on some Tirth Yatra, and they were in the depths of the Himalayas in Badrinath on the relevant date, so they could not possibly have done all of this, then you can get them off, right? So look for those kind of things.
Ma'am, so this happens only when you kind of have something cogent at the time of the trial. But once the person is, being mangled and harrowed by the policemen, जब arrest हो गया होता है, is it like
Domestic violence में normally arrest तो होना ही नहीं चाहिए.
Okay.
Domestic violence में क्यों arrest होगा?
Ma'am, in such other cases,
arrest होता है, see, don't confuse things. Arrest होता है 498 में, ठीक है? So don't confuse the two things, please, because everybody just files थोक में. They file 498A, they file 125, they file domestic violence, सब कुछ file कर देते हैं, right? Arrests happen in 498. So that's a story for another day, but I'll just give you a short example of how there was this is in Greater Noida. We had one matter where what happened was that the wife's uncles, two of her mamas were both policemen, and this was in Greater Noida. The uncles were in UP Cadre only, so they were posted somewhere, not in Greater Noida, but somewhere around, and they came down and they came with some policemen. They manhandled these people, and all of this happened. Now, what actually happened was that the police came and they forcibly took away these people to the police station, kept them there from morning till evening, and then Sham ko jakar, they registered an FIR ostensibly on the basis of a call to 100 saying that there was a domestic violence that had happened. Now, the call happened just a few minutes before the FIR was, well, about half an hour before the FIR was lodged, so it happened in the evening. And unfortunately for the police, there was a CCTV footage of the time when the police entered and the time when the police left, taking the person or persons with them to the police station. And there was also a CCTV footage of the balance of the family members also getting into their cars and leaving the home. So there was nobody inside the home, right? And there was clearly no footage of anybody having arrived half an hour before for any domestic violence or any kind of an incident to have taken place. So on the basis of this, we filed a 200. We wanted to lead pre-summoning evidence so that all these people could be charged. We took 13 people into the radius of this particular 200. And so as it happened, two things happened. One, despite the uncle's influence or whatever, the police stopped harassing us. Number two, of course, the magistrate didn't want to move because, the police were involved and, unka roz ka vasta padta hai unse, didn't want to prosecute them, etc., etc. When nothing happened for a whole year, we tried really hard to push it. The pre-summoning evidence didn't happen. We just picked up the matter and we went to High Court and we said in a writ petition, we argued the writ petition saying that, because the police is involved, because they behave like this, because there is a problem, so we are afraid and we don't want this matter to be lingering like this. And it should be dealt with. Now, while the writ petition was pending, the police came and something happened. So this man got really scared. We immediately moved a transfer petition in the Supreme Court, and we cited everything. We cited the fact that we had gone to the Allahabad High Court and the matter was pending, but it hadn't been able to be heard because of COVID, etc., etc. And we said that now the police is again threatening us. So please move this matter, transfer the 200 out of the jurisdiction of UP altogether and put it in any other court that is conveniently accessible. So if you want, you can transfer it to Delhi or Haryana or Rajasthan or Himachal. So close by, but not like don't transfer it to Chennai or something, but close by Uttarakhand also maybe a place where you can transfer. So when the Supreme Court saw the material and everything, they immediately said yes. They transferred the matter to a Haryana court, and that was the end of it. The matter, because it had come as a transfer from the Supreme Court, the judge was also a little worried कि ये तो Allahabad High Court भी चले गए, ये Supreme Court भी चले गए, अब मैं कुछ ठीक से काम नहीं करूंगा, मेरे against भी कुछ file कर देंगे. So the matter proceeded, and the minute the matter started proceeding, then if the opposite party started saying, please settle up with us. Because out of those 13 people, 7 or 8 were police people. तो उनकी तो सबकी नौकरियां जाती.
Right, ma'am. Okay. So very important inputs there. Guys, जो लोग chat में you're dropping messages to take your questions up. We will take those questions up. We have the time, but धीरे धीरे. So we'll take the follow-ups first, and afterwards we'll take the other questions. And also, many of the questions are on the same lines जिस पे अभी मैम ने answer किया है. So we will go into the depth of it. We'll take your problems and issues also, but that will happen in the course. It cannot happen in one webinar. So right now we'll take the questions, on the tangent of it, and then we'll go into the depth of it later. So, ma'am, taking up the next question, there's a follow-up by Mr. Saurabh, who wants to ask, can we go under section 482 of CRPC and invoke inherent powers of the higher court in the case of... Just a second, ma'am. Directly after we receive the summons for fake domestic violence case. So can we go to 482 for like quashing or something?
For a fake domestic violence case?
Yeah.
Yeah, any criminal case can be quashed in a 482, but you have to have very strong prima facie case. And please understand that in a strong prima facie case, it does not mean that you will ask the court to appreciate 50 pages of evidence. They're not going to do it. They'll say, go face the trial, show your evidence, and if you're not guilty, you will be discharged. So this is something that I repetitively tell everybody, that a quashing, when you go in a quashing, you have to show prima facie proof why this charge is not correctly framed against you.
Right, ma'am. Ma'am, another question.
अगर कोई domestic violence case file करता है, claiming that they lived with you for the past 2 years and that they broke up 6 months ago and you just disappeared or something and you've not been back so after that, and you left, you deserted them, etc., etc., and you are able to prove through your passport that for the last 2 years you were studying medicine in Russia, let's say, for example, and then you managed to get out with great difficulty during the Ukraine crisis, then you can file a quashing and say, get rid of this case. Or if when you read the complaint, you realize that there is no domestic violence alleged at all. What has been alleged as domestic violence actually doesn't fall within the ambit of domestic violence. Right? So then you can definitely say that this petition, please read it. There's nothing in it. No charges, no allegations against me. Right?
Got it, ma'am.
Okay. Uh-huh.
Okay, Saurabh any follow-up, you can drop it in the chat. Another question by Mr. Kailash Chandra, ma'am. He wants to ask how to execute an order or judgment in a DV case. In one of the cases, the applicant got the access to the matrimonial house, which was in the name of mother-in-law, but the whole family locked the house and shifted to other city. What's the option that applicant has to get inside the flat?
File an execution. The bailiff will go and break down the lock.
Okay. Okay, Kailash Chandra ji, so you need to get the locks broken by the bailiff. Ma'am, another question by Miss Poonam Mehta. Can the custody of the child be given to the mother when she left the girl infant baby and now the baby is 4 years? And how to help the husband inside that?
That's a tough one. The custody should remain with the father. There are judgments of the Supreme Court which say that the child should remain with the parent who has looked after them for the past 1 year, and this should not be moved because it is detrimental to their mental health and well-being, even though they should not be cut off from the other parent. But usually in the case of children, the court leans in favor of the mother. So you'll have to fight it out. It's dependent on the facts and circumstances of the case and how you present your case.
Right, ma'am. Poonam ji, you can share more facts if you want more clarification. Another question by Mr. Ram Kumar, ma'am. He wants to ask, I am a litigating party. Me and my old aged parents are falsely accused by wife under DV. They have been demanding punishment, huge settlement, and I want to know the maintenance for my wife and daughter. Like, how will it be decided?
It will be decided based on her expenditure, your child's expenditure, whether she's earning or not, what is your income, who are your dependents, what are your liabilities. All of these things will be taken into account.
Right, ma'am. Now, another question. Does non-payment of maintenance during Corona times and not returning Stridhan be considered as breach of a protection order? In the judgment, the magistrate passed the protection order. What is the scope of Section 18 protection order in DV Act?
Not returning Stridhan is not within the scope of a protection order unless you were specifically asked to return it. You don't have to return the Stridhan. That's a separate application that goes actually. And not paying maintenance is also not part of a protection. Protection order is essentially from a protection from abuse, physical or mental or verbal. So emotional, physical, verbal abuse, all that comes into play. Threats against the person or somebody close to them for whom they would be scared also come into play. And of course, if you are trying to dispossess the person from a residence order.
Right, ma'am. Ma'am, Sandeep Parmar ji has said that there are conflicting decisions from various honorable high courts around quashing of DVC cases under 482. Is there any authoritative decision from the honorable apex court on, for example, quash in a time-barred DV case?
Not that I can think of off the top of my head. That would certainly have to be looked into. And when you talk of time barred, please remember one thing, that there have been different interpretations and different high courts have come to the conclusion, and now by and large courts are following that this 2-year time period, if there's a continuing offense, if there are threats, etc., and the wife is very scared or she's being coerced not to file the DV, then it can be extended.
Right, ma'am. Also, I've noted this judgment down, Mr. Parmar, and I think we'll cover it in the course as well. We have made a bank of judgments though, but we'll keep on adding the judgments that that are important. Next one is by Ayushi Mishra, ma'am. She's saying, can the husband rightfully deny paternity test by virtue of some fundamental right? Should I read the facts? I think she's...
No, I think it's very simple. if he denies the DNA test, then the adverse inference has to be drawn against him. It's up to the judge. You can argue that adverse inference has to be drawn against him.
Okay.
And also, please remember that if he's making an allegation that the child is not biologically his, see, there are two things. Either you're making a statement that this is his biological child, or he's making a statement that this is not his biological child, right? Now, in the case of a marriage, the child is assumed to be the biological child of the husband. If the husband is contesting that biological fact, then he is the one who needs to prove paternity, not you. Okay.
Right. Okay. Reading the follow-up, ma'am. She says the wife was scared, alleged certain allegations in her first DV complaint as they were quite grave in nature. She was made to have sexual intercourse in front of the other family members. Can she first introduce them in her second DV complaint, even if that occurred before the first DV complaint? And am I right if I say that delay in filing DV complaint is not construed adversely?
No, I don't understand. I haven't understood this question at all.
Okay, I'll just give mic to Ayushi. Ayushi, can I please see you if you can come on video once? Yeah, got it.
Actually,
clarify first of all, Ayushi, that a domestic violence complaint can be filed anytime during the subsistence of a marriage, or a matter when you're staying in the matrimonial home, right? Or in a shared relationship, as long as the relationship sustains and you're sharing a household.
Ma'am, actually what she told me was that the allegations were so grave that she couldn't disclose them while she was filing the first DV complaint, as she was scared of her husband. But she wants to file them now. Now she has gained the strength to say this in front of everybody. So in her
but in her second, no. Now what happened to the first DV complaint? Did she withdraw it?
No, ma'am, she's planning to withdraw it because as she's saying that the allegations will not help her find a good relief. Therefore, she wants to file another DV complaint that is graver in nature so that she can get proper relief.
But now the question is, will she be able to prove all this? It's one thing to say that she was forced to have sex in front of the family members. How the hell is she going to prove it?
She won't be able. But her testimony, on her sole testimony, she won't get that.
That's going to be very difficult, not if you're going to introduce this at a later stage.
Okay, ma'am. And ma'am, is the delay in filing a DV complaint condonable?
It's filed after a period of 2 years?
Yes, ma'am.
When did she leave the matrimonial home?
Ma'am, before 2019.
Then you are okay because 2020, 2021, the period of Corona was going on. So there's no limitation that applies to all of those months, right from March of 2020 to October 2021. There is nothing that applies if she left in 2019. Uske 2 saal to pure hue hi nahi hai.
Okay. So 2 years limitation.
Okay. Ma'am, another question by Miss Poonam Mehta. She wants to ask if we want to show that the person was not in the position that he's alleged to be in location, will the Google locations be considered as a proof to show that husband, sister, and her husband, who are made part of a false DV case, were not present on the day or date when the DV was alleged?
How do you show a Google location?
Ma'am, it shows where have you been, na? That's how.
No. But let's say this happens after 6 months, the DV is filed. Is that Google location available to you?
If it is available, then is it usable?
Yeah, completely usable.
Okay, I think that answers the question. And Poonam says, yes, it is available. So I think that there's no problem in using it.
Yeah. So please introduce it along with the 65B. And if it is disputed, call Google. They'll send someone to testify. You can get them summoned.
Right. Ma'am, in such cases, do we also have to introduce an expert to testify whether the whatever scientific evidence we are getting is on point or not, or is it tampered or not? Do we have to get something like that?
Not really. It's for the opposite party to challenge it. Then you can ask for forensics.
Okay. Got it. Ma'am, Mr. Sandeep has a follow-up. Okay, guys, we have only 7 minutes and we'll not be able to take all the questions. So, jo bhi abhi aas-paas ke questions and we'll take those. Baki, next week we're going to have another webinar.
Do Raghav, you sort out the questions which are relatable to DV, because there are some questions which came for custody, this, that, and the other. Those we can maybe take some other time when we have more time, right? Okay.
Yes, ma'am. So we'll just take last 3 questions now. Ma'am, this one is by Mr. Sandeep Parmar. He wants to say in section 31, there is punishment of 1 year and 20,000 ka there is a fine. So in the event of violation of a protection order, okay, another participant. Okay. In the breach of protection order, will this be a civil imprisonment with simple labor or simple labor? I don't know what that means, but
it's not. Yeah. So domestic violence is actually a criminal act masquerading as a civil act masquerading as a criminal act. In G. Sorry. Stop it. Chalo. Sit down. Don't be a bad cat. Okay. Yeah. So it's a civil act masquerading as a criminal act. So your imprisonment will be civil. And that is something you must remember if you are the lawyer of the victim.
So, ma'am, this is going to be a simple imprisonment or a rigorous imprisonment?
Simple.
And can this be, is this challengeable under 29 appeal, the appeal provision?
That depends whether you have a ground to say that you should not be imprisoned or not.
Okay. Got it, ma'am. There was actually one question around this thing, DV being civil or criminal. So the person wanted to ask, why do we call DV a civil proceeding when there is violence in the name itself?
Because there is every criminal proceeding carries with it some penal consequences. In the case of a DV, apart from a protection order, there are no penal consequences. So if you violate a protection order and you infringe the protection order, then you can be imprisoned, and also you can be thrown out of your home and not allowed to come within 200 meters of the victim. So otherwise, if you don't pay maintenance or if there is abuse or whatever, there is no remedy as such, no?
Right, ma'am.
There's no penal consequences. That's one of the lacunae of the Domestic Violence Act, that there are no penal consequences. Behave yourself. Enough now. Stop it. No, sorry.
Right, ma'am. Ma'am, another question. What is the relationship between 498A and DV, and do these provisions get married in certain cases, and how do we use them?
So 498A, you have to show that there is violence because the person wants to extract something from you illegally, or you, your parents, whatever, your relatives, whatever. In domestic violence, the abuse can just be abuse. So it could be because the husband is an alcoholic, for example, right? And it does not necessarily have to coincide with you wanting to get some advantage out of the situation in a monetary way. That's the difference between a 498A and a domestic violence. So yes, right. Of course, there can be overlaps. There can be domestic violence because somebody wants dowry, and it can come under both provisions.
Right, ma'am. So before we take the last question now, I'll just inform once again to everyone about the DV course, because some people have joined just now. So we're going to start with this domestic violence course from the first week of April, and it's going to be just like CPC. अगर आप लोगों ने CPC का भी course लिया है, it's so many stories and so much experience that and efforts that ma'am is going to put into the course, just like she's done in CPC. It becomes effortless for us to understand the provisions, and awesome lectures. Everyone who has been to this, in the live class, या फिर जो लोग YouTube पे भी देखेंगे, do find the link in the description or wherever you can find. You can reach to Lawyers Club India on any social media channel, and you can go and enroll for DV and CPC, CRPC, Hindu laws, criminal, Muslim, so many that there are on LCI. And timing is going to be 6 to 8 p.m. on Saturdays. We might also introduce classes on Fridays later, but that's tentative. So generally it's going to be 6 to 8 on Saturdays. So taking up the last question now. Ma'am, this is by Mr. Sriram. It's a very small question. He wants to ask, a wife is indulging in adultery. Can that be used in a domestic violence case? And there's another part also, once you can answer.
Yes, of course you can. And you can claim that that is the reason why there's a domestic violence case, particularly when there is a long marriage. And if you have proof that, everything was happy and hunky-dory, and then suddenly things have started to go wrong only when this adultery started happening.
Right, ma'am. And ma'am, how can a woman claim her stridhan if the mother-in-law is having the custody of all her stridhan, for example, the gold?
406 IPC. When you file a 498A, usually you also file a 406. Go and lodge an FIR saying that she's not returning your stridhan.
Right, ma'am. Ma'am, Hetal has requested that you take family law divorce also as a part of the course, because they go together, and guardian and wards.
No, that I'm not going to do, because family law and divorce becomes very problematic in the simple for the simple reason that, let's say, divorce. So divorce is under the Indian Divorce Act. It is also under the Hindu Marriage Act. It's also under Muslim law. So the divorce becomes a problem if you take it up with domestic violence. But what we can do is that definitely we will talk about, to some extent, we're not going to talk about divorce per se, but we will talk about when it is harmful or dangerous to file a divorce petition, whether on part of the respondent or on part of the victim, and at what stage it becomes okay to file. That makes sense.
Right, ma'am. Or we'll also do a separate course sometime in the future on Hindu laws, complete all the Hindu laws. We'll keep on doing all that.
Yeah.
Okay. So, right. Okay, so we'll wrap it up right here. I would implore everyone to join in the course. I'll send the link once again, and it's going to be a very, very fine time that you're going to spend with us for like a few 20-25 hours, and it's going to help you in the lifetime. And so many people who have already taken ma'am's course, they can testify to it very easily. And we're going to start from the first week of April, and there's some early bird benefits and also. So do find the link and find the page, and keep coming back. Thank you so much, ma'am, for your time.
You're welcome.
And
good night, everyone. Okay,
good night.
Raghav, can you sign me out, because I'm going to be looking for the next 15 minutes as to where I'm to get out of this whole thing.
Yeah, do it, ma'am. I'll do it. In case anyone has any questions, reach out to me personally as well. My number is in the chat box. Link you already received. Enough of marketing. I guess you guys can find your way to the page now. Thank you so much.